There. My name is Evelyn Castillo-Bach. I'm the Executive Director of Balanced Justice Network. We are based in South Florida, and the focus of our organization is criminal justice reform. And today we're going to focus specifically on what are the ethical responsibilities and obligations of a prosecutor to recuse himself or herself if there's a conflict of interest or if there is a clear bias. And let's begin by going to the American Bar Association and seeing what they have to say on the subject matter. Now, the American Bar Association has focused on the issue of conviction integrity units, conviction review units, because a lot of cases in this country need to be reviewed. There's been wrongful convictions, there's been prosecutorial misconduct, there's been false testimony, there's been new evidence. There are any number of reasons why a case that's already gone to trial and where a conviction has been obtained and then new information arises and there's reason for the case to go back to court. And when that happens, is it okay for the original prosecutor who prosecuted the case to now return to that case? Let's see what the American Bar Association has to say. In May 2024, a report published in the American Bar Association Criminal Justice magazine called PCE, which stands for Prosecutor Center for Excellence, and I love that. Prosecutor Center for Excellence. I mean, in my opinion, prosecutors play a vital role in our society. They're critical to our society. And when they do what they're supposed to do, we are all served very well. And it's an honor and a prestige to be a prosecutor. However, when prosecutors engage in conduct that is illegal, unethical, or compromised, then we are all hurt by it. But proceeding with what the American Bar Association has to say, the American Bar Association Criminal Justice Standards for the prosecution function establishes that, quote, the primary duty of the prosecutor is to seek justice within the bounds of the law, not merely to convict. I think a lot of prosecutors miss that point. If you've been following some of my other broadcasts, you will see that I have been documenting how in the case of the Miami-Dade State Attorney's Office, the conduct of the prosecution over years, it's a toxic culture that has been caught out in a wide range of misdeeds and mishaps, and we're not going to go into those details today because I've spoken to that in other broadcasts, and I will continue in the future. I want to really focus on the American Bar Association and what they have to say about the role of prosecutors and the proper way for prosecutors to behave, specifically when a case returns to be reevaluated or to address issues of actual innocence or new evidence or false testimony, whatever the case may be. But according to the American Bar Association, as published in May 2024, there is, and I'm quoting now, that there is consensus that the prosecutors or investigators involved in the original conviction under review should not oversee the reinvestigation or be responsible for the ultimate decision about the case. Whether in truth or in appearance, these prosecutors and investigators cannot provide the independent and unbiased review that is so crucial to a criminal review unit or a criminal conviction integrity process. As a matter, and they continue to write, and I quote, as a matter of professional courtesy, however, the original prosecution team should be notified of the decision before it is made public. So in other words, the American Bar Association clearly states that if you're a prosecutor and you were involved in a case that is under review for reconsideration, perhaps for resentencing or perhaps for a new trial, to evaluate the new evidence, if you were part of that prosecution team, you got no business in this phase of it, okay? Because you're compromised, you're biased. It's clear as day. That's what the American Bar Association says. The American Bar Association goes on to write that there are two schools of thought on whether the original prosecutor should be consulted, not that they should be involved, but whether they should be consulted during the reinvestigation. And the 2 points of view are: one, according to one view, the original prosecution team should be interviewed about the case, as they may have valuable information not known to others, provide background information about a witness, or have insights into other avenues of inquiry. So that's one school of thought. The other school of thought is that holds that the original prosecutors and investigators should only be consulted on a case-by-case basis if there is a specific case-related reason to do so. And for those who want to actually go back and look at the actual source of my citation, I refer you to the Criminal Justice Volume 39, Number 1, 2024, by the American Bar Association. In conclusion, this report by the ABA states, in the modern era, a prosecutor's office that conducts conviction review acknowledges that the criminal justice system, like all human systems, is not immune from error. I mean, that should be pretty obvious, right? I mean, people make mistakes. Prosecutors make mistakes. Everybody makes mistakes. Judges make mistakes. Continuing. In the face of that reality, writes the ABA, prosecutor's office that adopts a conviction review unit or conviction review process, or helps another office to do so, demonstrates its dedication to achieve justice in every case. Still, the true measure of integrity is to learn from and build upon experience to prevent wrongful convictions from happening again. More than 20 years since, and then it goes on to talk about a gentleman who was exonerated in the role that he has contributed to encouraging the development of this process. And the reason I bring this up today is to take that standard, that orientation, and look at the Miami-Dade State Attorney's Office, led by Catherine Fernandez-Rondon. Right now, there is a case. It involves my son, who was convicted of a felony, a life felony, which means there's no probation, no parole, was convicted of a life felony that in fact does not exist under Florida law. And this was brought to the attention of the prosecutors back in 2015, and the state attorney's office just rejected that. They said it's time barred, you should have brought it up before, too bad, too late, go die. And more recently, we discovered that there were issues with juror misconduct. And we brought those issues before. We filed a motion requesting a new trial based on juror misconduct. Originally, it looked like there was 2 jurors that engaged in misconduct, because the transcripts that we had available, that our investigators had available, were the trial transcripts. The clerk of courts said that the questionnaires that the jurors have to fill out were gone, that they were destroyed years ago. We were talking about a case that happened, a trial in 2002. So our investigators depended on the trial transcripts to determine whether jurors had lied or misled the court during voir dire, the process of answering questions about your background, your family's background, any criminality, that sort of thing. And initially, it looked like 2 of the jurors had lied. Then after we filed, the prosecutor, the state, came back with a counter motion, and they actually produced the questionnaires. Hello. We were very happy to see that. But the clerk of court said it was destroyed. But somehow the prosecutors had it. The prosecutor had it. All right. And with some tugging and pulling and urging, we finally got our hands on that. And we could see that, yes, okay, in fact, one of the jurors had actually admitted on the written form that she and her family had some criminal history, and that she was embarrassed. She didn't want to bring it up in court, which is why it didn't appear in the court transcript. But it did appear when our investigators did a background check on her and her family. So we said, okay, even though she didn't admit to everything in writing, she admitted only to some of it in writing, not all of it. We said, okay, fine. We can see that she admitted to some of it. We set that aside. We'll focus on the remaining juror, where there's no question marks, no ifs, no ands, no buts. He said no to any type of criminality by himself or his family in the questionnaire that he signed, and he remained mute in court during the oral questioning, admitting none of his family or his own issues having to do with any arrests and that sort of thing. So that one is very solid, and we're not going to focus on that one today. We're going to go back to that one some other day. But returning to the prosecution, and what's the ethical thing to do? What has happened in this case is that the Miami-Dade State Attorney, led by Catherine Fernandez-Rundle, has violated this entire concept, right? No. It's like they don't know. They don't know what the American Bar Association writes about, or what the recommendations are, or what the proper standards are. No. The prosecutor who is fighting us on a motion for a new trial based on juror misconduct is the same prosecutor who prosecuted the case back in 2002. Exactly the same person. Unbelievable. And not only that, we have recently discovered that this prosecutor also has a background that may be cause for her to recuse herself because of her own publicly stated predisposition and bias when it comes to people, or specifically men, who have been accused of sexual assault. And I'm not going to go into the details of revealing that at this juncture, because I suspect this is going to come up in court, but it's in a newspaper article in the Miami Herald, published years ago. So the question becomes, should the state attorney's office have ever permitted this prosecutor to take ownership now of this case again? I mean, she's totally biased. How do you justify this? This violates basic standards of prosecutorial ethics and integrity. Basic standards. It's unbelievable that nothing learned in this office of the state attorney's office. That they basically, it's a culture where they basically feel they can do whatever they please, however they please. Ethics be damned. They want to keep their conviction at all costs. Justice be damned. They have lost their way. They really have lost their way. And I placed full responsibility for this on their leader, Catherine Fernandez-Rundle. She's responsible for making sure that her prosecutors understand what their true role is, and that they don't bring their biases into it. And in this case in particular, this prosecutor shouldn't be within 1,000 miles of this case, and yet she's the one who's fighting us tooth and nail, insisting that my son should die in prison, because that's what a life felony constitutes. She wants him to die in prison in a he said, she said case, with no guns, no drugs, no gangs, no trafficking, no violence, no serious injury. My name is Evelyn Castillo-Bach, Executive Director of Balanced Justice Network. Thank you for taking the time to listen. Be well.